Sure, I work on norms in international relations, um, and I look at norms as elements of social ordering. I'll tell you a little bit about how that came about because I'm part of this movement that set up the field of constructivism in international relations in the 1990s. And there we had ideas and discourse and language and norms as new elements that were structuring political behavior and constructing international relations. And so from there on, I was part of the group that developed the field, a subfield that we call norms research international relations, and on which I've now done a couple of books, and we are currently working on a handbook, an Oxford handbook on norm research in international relations. The field really, norms, since they are such central elements, I find it absolutely fascinating to study norms, because without norms, the world wouldn't function. And so we need to see how, I mean, they structure our interactions, but they are also constructed by our interactions. So you see immediately that for us to interact is a basic element for world politics to actually work. And I found that fascinating in a way that there are various ways of looking at norms. Some people simply look at them as carrying standards of behavior and that are well known to members of a given community. But of course, the world is not one single community. The world consists of many communities, and some people are at the margins of communities, and there are small communities and large communities, and some are more formalized than others. So that led me to thinking about norms as the glue of society and international politics, quite in the way that Polanyi once looked at societies, the way we need a glue of kind of a what constitutionalists call a soft cultural underbelly of what's happening. So we have a strong rule-based order and a background, but that rule-based order can only function if people believe in the rules. And that's what I see norms doing, and that's where I try to offer a framework and an approach, and then to do field studies and empirical research on most research has been going on single norms like human rights, the power of human rights, torture prohibition, gender rights, and so on. But it seems to me that we need to know more about how norms hang together in the world, especially as we're living in a world of migration and globalization, and we're all affected by the polycrisis at different sites around the world. So we need to know much more about the entanglement of norms. Some lawyers have made an inroad there, looking at the many paths of international law, like Nico Krisch and Elgi Yildiz in Geneva. But in the field of international relations, we have yet to do that. And that's where I am at the moment, I guess. Well, that's actually a situation or an opportunity, I would say. I'm talking about the contested use of staatraison, raison d'état, or reason of state. And it's an opportunity to use the methodology and the analytical framework of norm research in order to approach a very delicate situation in international politics. Obviously, we have Gaza in the background, and it's often the elephant in the room. I have attended so many talks where the entire room was filled with young students, colleagues, a very diverse group, also now in Cambridge, where important judges were giving talks or professors, and everybody wanted to address the issue, and people ended up not talking about it. People were not prepared to talk about it because there are issues of contention which are perceived as threatening for almost everybody involved. And so in what I thought, after following a lot of conversations with colleagues, especially outside from Germany, who had no idea what staatsräson actually was. And so I thought, well, it is a fundamental norm. It is used as a fundamental norm, the reason of state. I mean, if you relate to the reason of state in order to legitimate your international or national political decision-making, then it turns to be a fundamental element of politics, legitimizing politics. So my question was, in the first place, what's actually on this norm? If a norm carries meaning and values, and it is indicative for behavior by way of behavioral instructions. So then I thought, well, we do have the tools in norm research. We can look at it and simply look what's on the norm, what has been layered onto the norm through practice over the centuries. So in my first move, in the paper that I first presented here a little earlier this year, I looked at kind of history a couple of centuries back, in philosophy, Machiavelli, and so on. When you actually refer to the raison d'etat. And I came to the point where Angela Merkel, the then Federal Chancellor of Germany, referred to staatsräson before the Knesset. And she basically said, this means we stand in unwavering solidarity with the state of Israel, come what may. And then the norm hadn't been evoked much until the 7th of October atrocities last year. And so then it was evoked again by then Chancellor Olaf Scholz. And so the question then became, what does it actually mean? And it was referred to a lot in the press. So the papers then picked up on using the term staatsräson. And I sometimes feel even staatsräson sounds like a very, almost like blitzkrieg. So it has this kind of Germanic kind of way of pronunciation that you almost kind of stand still. And so that's why I sometimes use it to shake up people when I'm giving a talk. Reason of state sounds very like rule-based. But staatsräson is not really rule-based. It's more kind of, it's more about a moral obligation following the Holocaust atrocities by the Nazis. And so that's of course, everybody sees that and understands that. But the question is, if we evoke it in order to legitimize political decisions, then this needs to be elaborated and explained to the public. And that's something where I found increasingly the public was not sure what it actually meant, let alone people who were outside Germany who had no knowledge about the norm being used in order to justify decision-making by heads of state and representatives of government. And so people ask themselves, does this actually mean evoking raison d'etat? Does that mean that the German Bundeswehr is supposed to support the IDF in warfare? Or how far is that to be taken? And politicians were a bit like avoiding the answer. And so to the extent that some people seemed to indicate yes, and others said absolutely not. And so then what I'm going to talk about today is much more like, how has that developed over the past year and how has that been used? And we see that in a lot of cases there was like a muddle between various norms. You could say a norm bundle around. We had raison d'etat, we had genocide, we had from the river to the sea, we had anti-Semitism, and all of these norms were used in a connected way, but lacking an explanation that was convincing, That was documented by lots of protests, people losing employment, people being sort of subject to threats of being fired, a Secretary of State being fired in the Ministry of Research and Education. And so there was, you couldn't say that the norm helped in any ways to structure politics in a meaningful way. And that's the two cases I'm talking about later, is like going back to the framework of norm research. You could basically say we see norm bundling, that raison d'etat is used to justify the reference to court rulings in particular cases. And I'll speak about that a little more later on. It's a Berlin case where a Palestinian, sort of pro-Palestinian protester was actually reprimanded for using the slogan "from the river to the sea." And the reasoning of the judge was, this is based on raison d'etat, staatraison. People have felt they were not enabled, they were not invited to discuss, there was a lack of public discourse. And so my last piece finished with an invitation, a suggestion for the German government to extend an invitation to dialogue, to speak about this. This has not happened, and so what we now see, and the ICC ruling on the warrant of arrest for Netanyahu and Gallant really bring that to a situation where we see now a norm collision. Because the question that the Germans are now as signatories of the Rome Statute, Germany is obliged to implement international law, and therefore would have to, as German lawyers have developed and elaborated in the press following the judgment, the German government would be obliged to actually arrest Netanyahu in the case of his visit to Germany. But, and I talk about that a little more in the afternoon, this is not necessarily a done deal, and leading politicians have not actually confirmed that they will do that. And so what we see there, and very helpfully, norm research has another concept to analyze that, and that's norm collisions. We have a collision between, and this is really paradoxical, because we have a collision between a staatsräson, which is a norm that was developed and established following the German atrocities in the Holocaust, and the ICC, which is also an institution that has been set up, especially with support by Germany, as something that, in order to counter a similar development of the German Holocaust. And so we have this collision between, do we actually follow the ICC ruling, or do we use staatsräson? And you see by leading politicians currently in Germany that some politicians lack the knowledge of how the ICC actually works. So we are all claiming to be part of a rule-based order, but very few people know what it means. And I think that leads me to your next question. And that's exactly the point where I think we have, there's a lack of interaction in order to generate knowledge about the rule-based order. The rule-based order is a good thing, but if we are unable to communicate A, its meanings, and B, sort of draw people in, and that can only be done on the basis of intersubjectivity, to generate an intersubjectively perceived legitimacy of the norms that form part of the order. And this, of course, is not, I mean, I can offer this example in Germany currently, where we certainly have too much silence and too little dialogue. But this is on a micronational, in a micronational context, if you wish, in the larger global world, what we also see happening in a context where we are mindful of the colonial conditions that led up to the construction of the United Nations Charter Order. And we see a lot of sort of research where, on the one hand, lawyers will say, oh, well, but there's all these signatories of the rules that form part of the Charter and so on, the principles. But there's other research that looks at the embeddedness of the negotiations at the time, be it for any convention that we see. And they often find that people from the Global South were dealt with in a condescending way, that they didn't have access to particular fora, that their kind of influence was not properly represented in the spirit of the law. We see the black letter of the law that's there, but it's always, and that's perhaps where I can I don't know, conclude, but it's really it's one thing of what you actually want a norm states to be, and human rights, everybody will say, oh great, we go with it. But if you start thinking about what does the implementation of human rights mean, and you come down to migration and border crossing and saving people at sea, then all of a sudden it doesn't seem so entirely obvious what it is. And so that's where I think, that's why I take this ethnographic approach, follow the conflict, go into the midst of the problem and the mess, as Fritz Kraftwerk would say, and see who are the contestants in a case, and then go back up and see what we need to change.